Welcome to Sakshi TV's special immigration show with attorney Ms. Prashanthi Reddy from the Law Offices of Prashanthi Reddy PLLC. Please note that Sakshi TV now has 3 immigration shows every week. On Tuesday at 3 p.m. EST with attorney Ms. Sheila Murthy, Wednesday at 5:30 p.m. EST with attorney Prashanthi Reddy in English, and on Friday at 6 p.m. EST with Mr. Bhanu Elindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice and is for general informational purposes only. Sakshi TV or its agents will not be responsible for use of information. If you need specific legal advice, please contact the attorney directly. Ms. Prashanthi Reddy needs no introduction, but if you need consultation, please log on to reddyesq.com for contact information. When you connect with them, don't forget to mention Sakshi TV. From the beginning, reddyesq.com has put a wealth of free information and online tools in the hands of immigrant community and for the benefit of US employers. The reddyesq.com site provides you with the latest and cutting-edge information on US immigration law and policies explained in terms you don't have to be a lawyer to understand. Today's topic is how to get green card based on EB1, EB2 and EB3 categories along with the Perm certification. We will continue the knowledge session along with the latest news and immigration Q&A. Before we get into the topic, you can call us on the numbers on the screen for questions related to immigration and also ask for tips. Hello, Ms. Prashanthi. Hi, Ms. Reddy. Can you hear me?
Yes, Tony. I'm good. Can you hear me?
Yes, I can hear you. So, should we just get started with the immigration updates for this week?
So, we can just get started with the topic because I don't have any immigration updates. It's been a slow week.
Right. So, Ms. Reddy, since we're talking about Perm certification and employment-based green cards, I'd like to start off with a basic question of what is a Perm certification and who needs it?
So, just to go back a step further, we're talking about employment-based green cards today, and this is a series that we'll continue for the next few episodes, depending on the interest. But, this is one of the most important ways of getting a green card. There's employment-based, and there's, of course, investment-based, which is EB5, and there's family-based, if you have immediate family members that are willing to sponsor you for the green card. But for Indian nationals, I think the maximum utilized is the employment-based, and most Indian nationals get their green card via their employer. So it's important to understand, what is employment-based green card and how to get it and what the steps are. So even the employment-based green card, there are many ways of getting it. One is directly through employment, that is your employer sponsors you, and you could be either under EB2 or EB3 category. So an EB2 category, the difference between EB2 and EB3 is one, the EB2 requires an advanced degree. That means a master's degree or a bachelor's plus 5 years of experience, which is considered to be an advanced, equivalent to an advanced degree. And the EB3 is a job that requires, a bachelor's or lower. So depending on what the job requirements are, you file either under EB2 category or EB3 category. The difference also, the significance of the categories is that the visa numbers availability, because as you all know, in order to actually file the final step, which is a 485, there are only a few visa numbers that are available every year. And it's about, from the total worldwide numbers, about 7% numbers are catered to each country. So in India, even though has so many people filing, has only 7% of the visa numbers worldwide. So, which means that there will be a backlog because there is more demand than there is supply of visa numbers, right? So it becomes very important because the visa numbers for EB3, the availability is very different from EB2. And if you look at travel.gov and look at the visa bulletin, you will see, what the difference is. There's a difference of many years. So, and sometimes EB3 moves faster, as we've seen recently, and sometimes EB2 moves faster. So it really depends on really, I mean, my suggestion is to file for the highest of it that you are capable of filing, and then you can always downgrade. So if you qualify for EB2, I suggest you file under EB2. So without trying to digress further, because we're strictly going to be talking about the processes of a green card and how to get it, and we're going to start off by some general information as to how to file the green card. So there's, as I said, if it's filed by the employer, you could be in EB2 or EB3 category. You could also be in EB1 category, which is exceptional ability. For example, if you're a researcher and you're researching, your research is important for US healthcare, then you could be under the researcher category in EB1. Or if you are of an exceptional ability, that means you're a singer, you're an artist, you have won many national, international awards, then you could be EB1 artist or EB1 sports person. And for that, you don't even need an employer. So those are some instances in which you can self-sponsor, right? So, but what we're going to talk about today is cases in which you need an employer, and in which which is not EB1 but it's EB2 and EB3. Therefore, you need a Perm application. So our main focus will be on the Perm application today. For the EB1, you don't need a Perm application. You can file directly the second step, which is the I-140, and then the third step, which is the 485, and you can file the second and third step together. But for a majority of employment-based green cards, they fall under the EB2 and EB3 category, and in those categories, a majority of them, again, need a Perm application. So what is a Perm application is what we're going to be talking about today. And that comes to Thorni's question. Sorry I took so long to frame the question, but just some useful background. The Perm is an application that's filed with the Labor Department. It is filed, can be filed online or can be filed by mail. Most people file it online. You have to open the employer has to open an account in the Perm website, and then you will be able to fill out the form online and check progress of the case online, and you will know when it gets approved, if there is an audit, etc. So it's a very useful application that they have. Now, the purpose of filing the Perm is to determine or to show the Labor Department, you're filing it to the Labor Department, that there are no US citizen or permanent resident candidates that are available and willing to take the job. And that is why you're offering this permanent job to your employee or to a future employee. And so in order to show that there are no willing and able green card holders or US citizens for the job, there's certain process that has to take place before you actually file the application. You have to place advertisements. And after placing of these advertisements, and then again we'll get into what those advertisements are and how they need to be placed, blah blah blah. But for now, it's suffice to say that after doing all the advertisements and waiting for applications to come in, the employer then prepares something called a recruitment report, which is a report of what resumes he got and why he rejected those applicants and why he is not, and to prove that he is not able to find any applicants that are suitable for the job. Now, the reasons for rejection, of course, have to be valid. They have to be as per your requirements that you state, that you're going to state in your Perm form. So they're going to look into that very carefully. You have to show that you actually contacted the applicants, and if you are not able to contact them or they didn't respond, you have to send certified mail letters to them calling them for an interview. And if they don't respond, then you can always say in your recruitment report that they didn't respond, therefore they're not available. Also, you don't have to consider applicants who are not permanent residents or US citizens. So these are the requirements are pretty strict, that you scope out the market, you do your advertising, you try to find qualified candidates, and if you're not able to, then only then you can proceed with your Perm application. So that's what you have to do before you actually file the Perm application, and there's several different types of advertisements. in several different types of media.
Right. So, Ms. Reddy, does a person, go out and fill the application on their own, or do they need an employer for this? Because it's a part
So
of
as I said,
the employment green card application.
right. So it's an employment-based green card, which means they cannot file it, they cannot self-petition for the Perm. We are talking about filing of the application through an employer. That's the process we're talking about right now, via the EB2 and the EB3 category.
Right.
Yeah. So we're talking about the general, in general cases, there's some exceptions, but in general, yes, the employer has to petition for them. The employer has to open an account. The employee cannot open an account in the Perm website and then file the application himself. In fact, there are very strict guidelines about that also. The employee is not supposed to participate in any of these activities directly. It is the employer who's supposed to move forward with all these activities. The employer has to place the advertisements. The employer has to have interviews. For example, especially for technical positions, you have, a technical interview. And you can't have your employee who you're filing the Perm for conduct a technical interview, even though he qualifies to conduct one, he or she, but you cannot have them do it. The HR or someone else in your office has to take care of it. So it is something that is completely driven by the employer.
Right. So
there are even some things that the attorney cannot do. Attorney cannot conduct interviews. Right? Attorney cannot directly place advertisements for you unless that attorney is working for you as an employee.
Right.
So there's lots of things that there are lots of do's and don'ts.
So, Ms. Reddy, where in all of this procedure or process does the role of an agent or an attorney come in? How can they help?
So the attorney can fill out, of course, prepare all the paperwork for you. So what we generally do is we give the employer all the instructions from A to Z. We discuss the draft of the advertisement. So first thing you have to do is you have to get from the employer what is the job, what are the requirements for the job. Then the attorney can help you draft the requirements. And advertisements cost money, so the attorney knows how to draft the advertisement once the attorney gets the information from the employer as to what the job requirements are. They know how short or how long the advertisement can be, what shortcuts can be used, what the content of the advertisement needs to be. So that's the attorney's role, especially in a Perm application, is very crucial, because this is one of those things that it's not a do-it-yourself thing. There are many other applications that you can get by doing it yourself, but here there's a lot of information and law that goes behind actually even just filling out the application and drafting the duties and making sure that they are not more than what the DOL would accept as requirements for that particular job.
Right.
So everything has to be within the parameters of DOL's expectations. So that only an attorney or someone who is well versed in immigration law can do.
So basically it's not a DIY, and a person would definitely need the help of their employer and an attorney to get through this procedure. So coming to this, from this, I have another question. So what is the processing procedure for a Perm certification?
Right. So we discussed a little bit of that. I told you that advertisements have to be placed, and we can go into that in a little bit more detail. So there are 5 different advertisements that need to be placed. And, so there's a newspaper advertisement that has to be placed for 2 consecutive Sundays. There is, and then there's a Department of Labor website advertisement that's done online. So these two are the compulsory advertisements that have to be done for every Perm. Now, in addition to that, there are 3 other ads, and also the notice of job opportunity, which is you're giving notice to your employees by posting something on your intranet or in your office saying that I'm doing I'm filing this for so and so. This is the job. This is the salary, and if anyone has any questions, you can contact me, etc. So you're letting your employees know that this is being done.
Right. So, Ms.
So
Reddy,
that's the notice of, yeah.
I'm sorry, I didn't mean to break you. Please go on.
So the NOJ is the third compulsory advertisement. In addition to that, there are 3 more advertisements that have to be placed. So altogether, I guess 6, not 5. So 3 other advertisements. You have a choice between, you have a few options, but what we usually do, because we try to decrease the cost for the employer, so we usually do an online advertisement, and then we do an employer website advertisement, so the employer can place something on their website, and then we do a referral program, which if done properly is it's fine, but there are some nuances to using a referral program. Certain terms and conditions have to be met, and sometimes it raises a red flag, but we've been able to successfully use the referral program as a source in the advertising, and only the reason we do this is to again save money for the employer. So we do the website, we do an online like Dice or Monster, or you can Indeed, or you can really use any online job source. It doesn't have to be a well-known one. It can be obscure, it doesn't matter. And the referral program is basically your advertising. You're sending an email, for example, to all your employees saying that, hey, this position is open. If one of you wants to refer, if one of you refers as a candidate and if the person is accepted, we will pay you XYZ. That's really the meaning of a referral program. And you can even put that on your website as proof that you have a referral program. So those are the ads that we usually use, and we find them the easiest to use. But in addition to that, you can use newspaper, you can use television, you can use radio, you can use on-campus placement, like you can go to a college campus and be part of their placement, their job fairs. You could, so there are many different paths that you can follow.
Right.
So once, yeah.
So, Ms. Reddy, yeah, please go on.
Go ahead.
Now, what kind of audits should one expect from the Perm?
Okay, so let me just finish the ads still, because I have not finished it. So
I'm very sorry.
And then I'm going to answer your question about the audits. So once that is done, there's a requirement that you wait for 30 days for each, for getting resumes. After each ad is placed, you have to wait for 30 days after the end date of the ad. And then during that 30 days, it's a cooling period. You're waiting for resumes to come in. At the end of the 30-day period, as I was saying before, the employer has to prepare a recruitment report with a list of all the applicants. If there were no applicants, he simply says, they simply say that there are no applicants. But if there are applicants, they have to list the applicants, list the time and date that they spoke to them, and then list why they were not accepted for the job, why they were disqualified for the job. And the reasons for disqualification cannot be that, their communication skills were bad, or because that is not one of your requirement, unless it was one of your requirement and it's a sales job. And good communication is one of the requirement. You cannot really reject candidates for a reason that is not enumerated in your job requirements. So be very careful when you're filling out that recruitment report and preparing it. And again, the attorney can help you to tell you what is allowed and what is not allowed in a recruitment report. What reasons you can give to justify and what you cannot. What reasons you cannot give to justify not selecting a candidate. Or you can choose to select a candidate, which is fine. Maybe you place advertisements, you get really good candidates and you choose to hire them. You could do that, and then you can continue the green card processing for your candidate that you want to as well, as long as you hire that person who qualified. So that's the story. If you don't get any qualified resumes, you process, as I said, it's the ETA 9089, which is an online application form, and it has to be filled out. And again, there are many nuances on how to fill it out and what to put. There's nuances about travel, about roving employees, about salary, etc., etc. So even before you actually place the advertisement, the other thing that I forgot to mention is what we do. We also have to get a prevailing wage determination from the Labor Department. The prevailing wage will determination will tell you how much wage you're supposed to pay for that job. And that's the wage you have to put on the form when you actually file the form. So you can't actually start the process of submitting the application until you get the prevailing wage determination. Okay, so then once that is done, it takes about 6 to 8 months for the DOL to get back to you. Now it could be a straight approval or it could be an audit. Audits are generally random audits and they ask for the same thing. Very few audits are specific unless the company has some kind of a history or there's some reason for the DOL to suspect that you're not doing things the way they should be done, because it's all an honor system. You're not actually sending your ads when you're doing the online application. You're just making statements that you've done this ad, you've done that ad, but you're not actually submitting documents. So in an audit, they will ask for all those documents. They'll ask you to show all your advertisements that you've placed. They'll ask for your recruitment report. They'll ask for the resumes. They'll ask for proof of how you contacted those applicants that you rejected. So that's what happens in an audit. And also if your job requirements are over and above normal, what DOL considers normal for a particular job, then they would ask you for a business necessity letter. So you have to justify why you need a master's degree when a computer programmer, generally in the industry, people don't need a master's degree. So you have to justify what is the complexity of the job, or why is it that your company needs something over and above the industry standards. So once you submit that audit with all your documentation, which also can be done online, and your explanations, then the DOL will either approve or deny the case. If they approve, then you move on to the next step, which is the I-140. And if they deny the case, then you can try to correct those mistakes that you might have made, and you can resubmit your Perm, but you'll have to do the advertisements again because there might be some fault in the ads, or it could be that the ads have expired, because remember, each ad is only valid for 6 months. So I know that's a lot of information, but I just thought I would give you the entire, so that those people who are filing for a green card at least have the knowledge of what is happening behind the scenes. And you can ask, educated questions to your employer, to your attorney as to, what the next steps are and why certain things are being done a certain way.
Right. Ms. Reddy, I agree that was a wealth of information, like always from your office. So getting back to my question, what kinds of audit can we expect from the Perm?
Right. So audits are, as I said, mostly random, meaning that they ask for, it's pretty much a cut and paste, because they ask for documentation that that is not submitted during the Perm application. So they ask for the advertisements, copies of all the advertisements. They ask for the resume of the applicants. They ask for reasons for why the applicants were denied. So recruitment report, as I was saying earlier. In some instances, they ask for a business necessity letter, especially if you are saying that a master's is required when as per industry standards, a master's is not required for that job. So you have to write a letter explaining why the employer requires a master's degree. Or if you have some other special requirements, such as sometimes the Labor Department will say, oh, why do you need XYZ skill for this job? Why can't the skill, prove to us why the skill can't be acquired upon training? That is, after the person joins, why can't you train him in that skill? For most of our, for example, software skills, it's not something that the employer can afford to train an employee on a particular skill, right? Because there's a time period involved, there's cost involved, and it's not a simple thing to train a person on a new skill like C, C++, Java, whatever, right? So, and often we ask for experience in that skill. We don't just say that needs knowledge of that skill. And that's where, again, your attorney their expertise comes in. You word it properly, you ask for experience in that, using that skill, not just knowledge of the skill. So when they actually ask a question like that as to why that skill is needed and why can't it training be required, then in that kind of an audit, then you respond saying that, this is the expense for learning C++, this is the number of months it takes you to get a certification, and also we've asked for knowledge, we've asked for experience, not knowledge. Therefore, even if all this is done, there's no way that we can actually, when the person can actually get experience in it by just, taking these skills, by taking these skills classes. So, sometimes they do ask questions like that. Sometimes they have questions on the referral program as to how was it distributed, and if the referral program is not clear enough as to what the incentives are, when an employee refers another person to you, they might ask for further information on the referral program. Sometimes, if you're blacklisted, especially, meaning that if there was an audit on your previous labor cert, like you meaning the employer, if the employer had an audit on their case before and you didn't respond to the audit, even if you are withdrawing the case, you should always respond to an audit, right? Because it's compulsory to respond to the audit. They want to make sure there's no fraud involved. So even if you're withdrawing the case, it doesn't matter. So if employers don't, then they might be blacklisted. And if they're blacklisted, then an audit will also involve something called supervised recruitment. So supervised recruitment basically means that the resumes, instead of coming to you as an employer, the resumes will actually be directed to the Labor Department, to an officer handling your case in the Labor Department, and then the Labor Department will send you the resumes. So there's no way for you to say that there were no resumes, right? Otherwise, it's really an honor system. You can just say there were no resumes, and and often that is true, by the way, because most DOL Perm ads don't get resumes because people are clever. They realize that they are green card ads, and they don't usually apply to those positions. So it's really defeating the purpose. But those are the rules until they come up with a better system. So sometimes though DOL might suspect that something is going on, and so they might ask for supervised recruitment, in which case then the process is much longer because they'll ask you to re-advertise. They'll ask for the resumes to be directed to a certain PO box at the DOL. They'll send them to you. Then you proceed with contacting those applicants and doing a proper technical interview if it's a technical job, and recording all the questions and answers for your recruitment report, and then doing it that way. So an audit can involve supervised recruitment as well. So these are sometimes when there's a mistake on the application, or there's something that they don't understand on the application that you filled out, they can send an audit questioning something on the application. That's possible also. But usually 99% of the time, it's always just a random audit asking for copies of the advertisements and the recruitment report.
So is an audit close to an RFE perhaps? I mean, if they're asking you for correction of details or to double check some documents, can that
be? It's pretty much an RFE. The only difference is you can choose to withdraw an RFE case when you're in an RFE and not respond. In a Perm audit, you have to respond. Even if you're withdrawing it, you can say, I'm withdrawing this application, but I'm also responding to it.
Right.
So you cannot withdraw without responding.
Right. So, Ms. Reddy, how long does it take for somebody to get a Perm certification, probably sort of an approval or something? Since there are so many audits involved, I think this needs a lot of spotlight, the Perm certification in particular. So how long does this whole procedure take?
So the entire procedure can take some time because even before you file the labor cert, there's some prep involved, right? So we have to place advertisements, we have to wait for 30 days, we have to do the prevailing wage, we have to get an approval, which usually takes about 5 months plus nowadays. So, since that takes the longest time, I would say that the minimum time you have to wait before you can file the actual labor application is 5 months or 5+ months. Then you file the labor cert after you've done all the advertisements and everything in these 5+ months. Now remember, you can save some time by placing some of the advertisements before you get the prevailing wage, because you don't have to mention the wage in all the advertisements. You only have to mention the wage in one advertisement, which is the notice of job opportunity. So you can wait to do that, and you can do all the other ads in the meantime and do the recruitment process, so that by the time your prevailing wage comes in, then you have to wait, of course, for another 30 days. So you have to place the notice of job opportunity for 10 business days, and then you have to wait for a period of 30 days. So it's, as you can see, it's about 6 or 7 months just to file the initial perm. And then once you file the perm, it takes about 5 to 6 months for the case to get approved. It can take up to a year if there is an audit. And if there are more serious issues, that it can take longer. If there is an audit and the case gets denied, then if you file an appeal with BALCA, it can take several years. So yeah, the processing time is usually, if it's a straightforward case without an audit, about 6 months after after all the preparation has been done, which is another 6 months, so about a year.
Right. Right. So, Ms. Reddy, my next question is about the employers. I mean, you said that the employer also plays an important role in the PERM certification and all the filings. So, what is the process, or how long does it take for an employer to register and file an application online?
So, it is a simple process for them to register on the PERM website. If they have never, obviously you're registering because you've never done a PERM before, and in which case then they ask for some additional information sometimes. In order for you to register, they ask for your federal ID number or maybe your incorporation documents. They want to make sure you're a legitimate business. So that sometimes then can take about a week or so if they ask for additional documents, or maybe sometimes 2 weeks. So if you've never done a PERM before, don't presume that you can just register within a day, because sometimes time is important. If your employees if their 6 years is getting over and you need to file then within a certain defined period of time, right? Because as per AC 21 regulations, your employee can get a H1 extension beyond 6 years, either if their I-140 is approved or if it has been 1 year or more since the PERM has been filed. So you want to start that application as soon as possible, and sometimes it's a matter of days. It's a very tight schedule to file the PERM. So don't presume that getting your registration on the PERM website is a matter of same day. Sometimes it can take a few days, sometimes a week or two also, if you're a new company. So make sure you get that process done quickly. Once you have registered for your PERM application, you'll be given a username and password, and of course then you can change your password. And then if you are using an attorney, then you have to create a sub account for your attorney, and then your attorney will get their own username and password, and they can file applications on your behalf. Remember not to share your information, your password, with your employees or with anyone else, because then they could cause damage by going in and preparing applications on your behalf. So you don't want that to happen, or withdrawing cases. Any kind of mischief can be done. So yeah, while the PERM website is really useful and helps us file online, it's also important to keep your password and username safely, because sometimes people forget or lose their password, and then you have to email the help desk, and then it takes some time for them to get back to you and for them to reset the password. So it's not that simple sometimes, but it's a useful tool to have nonetheless.
Right. So I think that's a very good caution for all our viewers to remember to safeguard their passwords and IDs, and not let them into the wrong hands or have anybody else misuse them. So which brings me to my next question. Will the National Processing Center issue confirmation of receipt for mail applications?
Yes. So we didn't talk about mail applications much because not many people do them.
Right.
But there are many instances in which, I mean, I have done it a few times, and mainly because, sometimes the Perm website, it happens rarely, but it might go offline. So when the Perm website goes offline, even if it's for a day, and you need to file your application that day because you have a deadline with reference to when, your client's 6 years is expiring, right? You have to file it that 1 year, exactly 1 year before, or more if possible. But we do, people do things in the last moment. So in that instance, then you'll have to really file the application by mail. And it's fine. They discourage you from doing it, but yes, you can file it by mail. And in which instance that, you will then receive a receipt in the mail. Usually if you file it online, you don't really receive a receipt because you only have, when you log in, it'll say submitted. So that's your receipt.
Right.
But if you do it by mail, then obviously that's not the case. So you would have to get something by mail.
Right. Right. Ms. Reddy, I can't help but wonder, have there been any circumstances under which it is, mailing applications has been proven to be more successful than filing them online, perhaps?
I can't think of any, especially in the DOL context, because, and I think in other immigration, everything I think, in my opinion, should be made online. Life would be so much easier for everyone, because right now we are filing applications. Almost all applications are filed, especially done by attorneys, are filed in the mail. So we're talking about 300, 400 pages of documentation being copied, stapled, FedExed, scanned, waste of money, waste of manpower. And then that entire bundle is again returned. So imagine how much paper is wasted and how much of postage is wasted. Because if the case is returned back, or if they don't need that, they again send all that documentation back. So yeah, I mean, to your point, I think immigration would be much more streamlined, and they would need less people doing the job, checking the applications, opening the packages. There would be no mailroom. Now they have so many employees working in a mailroom where they first check packages. So, and checks, checks are written by hand. There could be errors in the checks. Checks could be misread by USCIS and sent back by mistake. So many things happen that can be avoided if applications are filed online. So yes, definitely I think that it's more advantageous to file applications online rather than file them via the mail.
Right. Right. Ms. Reddy, given the backlog for Indian nationals, what should be kept in mind before filing for a Perm applications? Is there any specific advice you'd like to give our viewers?
Yes, very much so, because we know Indian nationals are in a unique situation where they file their Perms, but 10 years later it actually gets approved, or maybe more than that. So by that time, the Perm, the job, the skill sets, everything might become stale, right? Because that job is no longer even available maybe in the market. Maybe they have, obviously in 10 years they would have moved on. They would have, even if they're working for the same company, they would have gotten a promotion. The skills, are never the same, especially in the technology field. There's always new skills that are being used. So, there's some things we need to do to ensure that, as much as we can, to ensure that, Perm remains fresh and the job and duties and everything makes sense. So we have to draft the duties in such a way that, the skills and the duties remain relevant. So obviously the employer, should require the most updated skills, not like, skills that are already outdated and will become even more outdated, moving forward. We have to be able to foresee a business requirement, meaning that if you try to file your labor certs for high requirement jobs that are hot in the market. If it becomes no longer, if that business requirement is no longer there for that particular job, then it's difficult for the employer to justify that they still need that person, and they are required to do that. When you're filing a 485, you're saying that I continue to need that person.
Right.
Make sure that the employer has no plans of moving out of the state. You can move offices within the same county or within the same metropolitan statistical area or within commuting distance. But if they plan to move to Florida next year, don't file it until they move, because in order to file the I-140 or downgrade the I-140 several years later, that like we had to do in so many instances this October when people wanted to downgrade because EB3 was faster than EB2. Their perms were actually approved a long time ago, some of them 10 years ago, 2006, 2007, etc., and we filed downgrades for them, and some companies had moved. So just as an employer, try not to move to a different state if you have green cards that you filed.
Right.
Offer a higher salary as you can, because your salary is only going to go up, it's not going to go down. But having said that, minor changes in the job, when you're filing the 485 10 years later, say, if your job has changed from a software engineer to, like a more supervisory level, then you're still fine. So those, small changes don't really make a significant difference. And a higher salary, lower salary will make a difference, but a higher salary doesn't really make a difference. Also, be sure you can prove that moving forward also you have the ability to pay. Remember, you have to show that you have the ability to pay from the date of filing to present. So if you're going to be refiling that I-140 and upgrading it or downgrading it, even at that time, 10 years later, you have to show that you still have the ability to pay or that you've been paying your employee the prevailing wage. So either make sure your tax returns look good, have plenty of profits, or make sure that the salaries are commensurate with your prevailing wage approval or the wage that you put in your perm.
Right.
So those are very important issues.
Right. So, Ms. Reddy, my next question is, how can a pending application filed under the perm be withdrawn?
You can simply withdraw it online. You can also write to them and send them a letter in the mail and say that you wish to withdraw it. In an audit situation, that's what we would do. We'll say we wish to withdraw it, include the withdrawal letter from the employer, and then also respond to the audit. If there's no audit, you can just withdraw it online. And then, you'll get a confirmation online saying withdrawn. This is mostly done when you want to refile a labor cert for that employee. Say you filed a labor cert and you know that it's going to be denied, or you filed it, there's some error in the application and you don't want it to be filed that way. Say you filed it in EB3 but you actually wanted to do it in EB2. In those instances, you can actually withdraw it and then you can file another labor cert. You cannot file a duplicate two labor certs for the same person. So just something to...
Right. So does this mean an employer need not wait for the confirmation from the BEC before he refiles an application?
So you should withdraw it, and when you withdraw online, you usually will get something. It'll show you change in status. It'll say withdrawn, and that is sufficient.
Right. So what is considered an acceptable newspaper or an acceptable journal for us? Is there a published list probably?
Right. So when we talked about advertisements, we talked about that we said that there's certain advertisements were compulsory, and out of that, the advertisement that was compulsory was the newspaper advertisements for 2 Sundays. 2 Sunday newspaper advertisements are compulsory, and it has to be 2 consecutive Sundays. So mostly there is actually no list of acceptable publication. Any newspaper can be used as long as it has a Sunday edition. But most employers will be able to identify those newspapers that are most likely to bring responses from qualified candidates. So you can't use some obscure newspaper, right? You have to use a newspaper which has a wide circulation. Mostly, I've received audits for that as well, saying that you've received so and so. For example, in New York we have the Daily News and we have the New York Times, and I've received audit saying that you've used the Daily News, which doesn't have as much circulation as the New York Times. So, you should have used the New York Times to tell us why you didn't.
Right.
And now that's an error from the DOL's part. And, we were able to successfully overcome and tell them that, hey, what you're asking for is ridiculous. Because it's not necessary that you have to use a newspaper with the widest circulation. You just have to use a newspaper with reasonable circulation so that it can reach as much as the audience that you seek as possible.
Right. So this,
Yeah. So I would say that, use an edition having, at least the widest or one of the widest circulations. Again, it depends on your area. For example, if you're somewhere in rural New York Times may not be the best option. Maybe Daily News is a better option because that's a regional rather than a national newspaper. But in that particular town, maybe that is circulated more or read more than the New York Times. So just use common sense and use a popular newspaper to advertise, and don't try to use an obscure newspaper to avoid getting resumes.
Right.
That's what they don't want.
Right. So, Ms. Reddy, as long as we're still on the advertisement topic, I'd like to ask what level of, depth or what level of detail should be given regarding the job offer in the advertisement?
So, as long as the employers are able to tell the applicants what the job is about, they just need to appraise them of the job. You don't have to give all the details about the job, right? So, regulations don't require employers to run advertisements that talk about every single job duty because they understand that advertisements cost money and they're per number of words, right? And sometimes it goes in the thousands of dollars. So you can keep your advertisements. You can use short forms. Number one, you can keep your advertisement short as long as there's a logical relationship between your advertisement and the actual job that's being offered. That's all that's required.
Right.
So at the very minimum, just a description of the job title, the name of the employer, the geographic area where the employment is going to take place. Means you can just mention the city and state, and of course you have to give the address of where to send resumes. So, and you can give a one-line. It can just be a one-line job description. Software engineer, design and develop software. It can just be as simple as that. So you can give a very short advertisement as long as there is, a short advertisement just to let the readers, the applicants know what the job is.
So since you said very important details and should be put up in the advertisement since it's costing money obviously. So you said that the employee's address is kind of an important thing. Does the the offered wage come into this importance? Should that also be mentioned in the advertisement?
Good question, but offered wage doesn't have to be mentioned in the advertisement.
Right, so it's just the employee address then.
Correct. The offered wage, once the applicants contact you, then of course you have to give them the wage. And then once they contact you, for example, I'll give you an example. In the advertisement, you can simply say software engineer and give a short job description. But in your Perm application, you will actually give a description and you will put in skill sets that you need. And the skill sets you're just going to mention various skill sets because you can't list all the skill sets in the advertisement. But once an applicant actually approaches you, then you have to go through all the skill sets with them. You have to ask them whether they have X, Y, Z skill set and test them on the skill. So as long as your recruitment report is more specific to the job, to the actual job, and quizzes the applicant on the actual job, the advertisement doesn't have to have all the details. Because the idea is that you are, in fact, getting a larger pool of people, and then you're selecting out the ones that you want, right? So that you're not restricting the pool of people by not placing those details. You're actually getting a wider pool, because more people will come, and then people might say that, oh, I don't have that skill set, or oh, I don't like that salary. And you can then, reject those candidates, or because they themselves have rejected you if they don't, they don't accept the salary. So that's a good reason to then disqualify that candidate.
Right.
So, so employers can definitely place general advertisements as long as the recruitment is done, properly.
Right. So that brings me to my next question. Should the employer obtain a prevailing wage determination before he starts the recruitment?
Right. We alluded to this kind of, but to go into more detail, some employers choose to first get the prevailing wage determination and then start the employment process, in which case then you're adding 2 or 3 months extra to your process before you can actually file the labor cert. But you don't actually have to wait for the prevailing wage to place the ads, because as I said, you don't have to mention the wage, right, in the ads. So if you don't have to mention the wage, then you don't have to know what the prevailing wage is. But this is the tricky thing. Once you place the advertisement, if you get a resume, you should respond to that resume within 14 days. Now, when you respond to that resume, you can't really then disqualify the candidate based on salary, because you don't know what salary you're going to offer them. So you can't say that, oh, I was only offering 90,000, but they wanted 150,000. What if the prevailing wage says 150,000? So you have to find other ways of disqualifying them, and you cannot disqualify them based on salary if you're going to do it that way.
Right, right. So in relation to this, another question, and that is it permissible to use the same prevailing wage determination for more than one application?
Yeah, absolutely. So you can, like, for example, do a prevailing wage for a software engineer. You can just say software engineers, as long as the job and the skill sets, if you're mentioning skills, or you can just say various skills, as long as that is the same and the job requirements is the same. So for example, you're requiring masters plus 2 years for all the candidates that are using that prevailing wage, because if you filed another prevailing wage, it would come out with the same wage because you're not changing anything. Yeah, absolutely, the prevailing wage can be used, but remember, a prevailing wage has an expiry date mentioned on the wage itself. So you have to make sure that you either file your perm before the prevailing wage expiry date, or you have to place your advertisements within that validity period of the prevailing wage.
Right, right. So Ms. Reddy, could you please explain to us the eligibility and process of EB3 to EB2 porting?
Yeah, so as I was saying, when you're filing the perm, you have to file it based on the job requirements. What the employer tells you is the requirement for a particular job. Based on that, you have to file it. This has, of course, nothing to do with what the person actually has. So it could be that the person has a master's, but it could be that the job, systems analyst job, for example, or whatever it is, business analyst, requires only a bachelor's as per the employer. So if they require only a bachelor's, and if they don't require 5+ years of experience, then the job would be automatically fall into an EB3 category, as I was discussing earlier about the EB2 and EB3 category. So it would then fall into an EB3 category. And when you're filing the I-140, you have to choose, that category. But if you're filing a labor cert, and if you're asking for a master's because the job requires it, then it will fall into the EB2 category. So those categories come into play, of course, only when you're filing the I-140. There's no mention of any category in the perm itself, only the job requirements. So when you're filing the I-140, if the labor cert qualifies someone for EB2, then you have a choice between filing an EB2 or an EB3. because the requirements can be downgraded but cannot be upgraded if you don't qualify. So, for example, if you require a master's degree for a particular position, as per the Perm, you obviously qualify for an EB2, but you also might qualify for, you also qualify for EB3 because an EB3 requires anything that's a bachelor's or more, right? So you qualify for both. So you can decide at the time of filing the I-140 whether you want to file that particular application in EB2 or EB3.
Right.
And this, of course, decision comes based on, so many considerations. The visa bulletin. Also, while filing the labor cert, the requirement of the job could fluctuate. Also based on the salary, right? Because usually if it's EB2, if you're requiring a master's, then the salary also will be more. And then the employer may not be able to pay or have the ability to pay that kind of a salary. So they may prefer to do it in EB3. So that's another consideration while filing the labor cert. What is the prevailing wage? Does the employer have the ability to pay that prevailing wage? If they don't, then, does the employer want to file for a position, for a lower position that he might have, in his company?
Right. Yes, Ms. Reddy, that brings us towards the end of our session. Thank you for giving us a very detailed overview, and thank you for answering all our questions in a detailed manner about the Perm certification. And like always, it was a pleasure having you on our show.
Thank you, Tony. It's a pleasure being here.
Thank you. You're watching Sakshi TV Live with me, Torini Makana. Thank you.